Hi there, how you doing? My name is Chris Luhrs and I am an attorney with Halverson Law. Today I wanted to talk a little bit about some of the things that you can do to resolve a dispute that you may find yourself in. And a dispute can be many things really. It can be a business deal that goes bad, or it can be a dispute that you might have with your neighbor. There are a lot of ways that you can handle such a dispute. A classic one is, of course, to file a lawsuit, and that is what I would describe as the formal process of beginning the litigation process. That, of course, would involve filing a lawsuit against another party, having that lawsuit served, and then actually litigating the matter in court. But there are also other steps and avenues you can pursue to resolve a dispute that fall short of actually suing someone. Mediation involves a scenario where you agree with the person that you have the dispute with to enter into a mediation that would involve you and in all likelihood a counsel representing you, and then on the other side, of course, is the person that you have the dispute with and perhaps their attorney as well. And there is typically a single mediator assigned to handle the dispute. And so really that individual is just there to facilitate a conversation between the two parties to try and resolve the dispute short of filing a lawsuit. So one side has the opportunity to present the side as they see it. The other side has the opportunity to do the same as well, and the mediator will facilitate a conversation between the two to try and arrive at some sort of resolution that works for each side. Arbitration is similar to mediation in the sense that it falls short of full-fledged litigation, but it involves, instead of a mediator, an arbitrator. And an arbitrator has the power to render a decision binding. So in many situations involving arbitration, one side would put on their case really before the arbitrator, and the other side would have the opportunity to do the same, and the arbitrator would actually have the power to render a binding decision at the end of the arbitration. Typically with mediation, the mediator does not have any binding authority, and so the mediator at the end of the mediation could not bind the parties to any sort of ruling to settle the dispute, whereas with arbitration, the arbitrator can do just that, bind the parties to the decision. And it's not uncommon for contracts among businesses, contracting parties, to have an arbitration clause which demands that the parties enter into arbitration to resolve any dispute concerning the substance of the contract or agreement. A lot of times individuals will come into our office, describe a dispute that they have, and we simply get on the phone with the other side, determine what it is at stake and what the issues are, and we can resolve something before even needing to go down the path of mediation, arbitration, or a full-fledged lawsuit. So if you find yourself in a dispute, certainly give us a ring, log on to our webpage and see if we can help you out. Thanks so much for listening, and I'll see you next time.